next audio is dedicated to give an overview of Indonesia evidentiary, specifically in civil proceeding. So, what is evidentiary in civil proceeding? It is a process of submission of lawful evidences. The purpose is to reach the variety of assertion or allegations submitted by parties. The goal is to determine the scope and the sort of legal relation between parties. In a case of breach of contract, for example, the goal is first to determine whether the contract is valid. And the next thing is to determine the outcome of the case. In case of breach of contract, then the variety, the evidence is to assure that such breach of contract really occur. In civil procedure here in Indonesia, there is the different nature of binding of truth compared to criminal procedural law. In civil procedural law, it is adopting what we call as positive system of proof. Judge is bound by evidences submitted by the parties. Unless it is proven otherwise, then judge is bound by the content of the evidences. There is no minimum numbers of evidences to be submitted in order to render a case. And in civil procedure, what judges are seeking is what we call as formal truth. The formality of the truth itself. The judges examine the case based on the facts and evidence. We're not going to seek more about the nature of the case or what we call of the motive of the perpetrators, for instance. So as long as the evidences clearly shows that such facts or occurrence did occur and resulted to such damages, for instance, then judge can render judgment. So it's different with criminal procedural law in Indonesia, whereas it is adopting what we call as negative system of proof. Unless judges got two numbers of evidences as a minimum, then judges cannot convict someone. So when prosecutors submitted a case, the minimum is two evidences. What we are seeking in criminal procedural law, or the judge is seeking, it is called as material truth. There is saying what we call as beyond reasonable doubt. Judge should be really sure when it comes to convicting someone of such crime. So the difference is civil procedure is positive system of proof, criminal procedure is negative system of proof. Civil procedure seek for formal truth, criminal procedure seek for material truth. Although there is no prohibition to seek material truth, but because passivity of judge is one of the most important principle in civil procedure, whereas judge is bound by the scope of the case submitted by the parties, also bound by the evidences submitted of the parties. That is why what the judge is seeking in civil procedure is called as formal truth. It's all about the parties. If they don't want to have a case, and there will be no case. It's different with criminal procedure, whereas the public prosecutor act on behalf of the people to maintain public order. So, who got the obligation to prove? Both parties. This is what is the implementation, what we call as the implementation of Audi et al. Trump partem. So we should, as a judges should hear from the other side too. Although plaintiff got their claim, the defendant got the rights to answer. The plaintiff can submit evidences, the same rights also for the defendant. And submission of evidence only categorized as valid if both parties present and they can examine the case. So both parties got the obligation to prove. What do they need to prove? What must be proven? The truth of facts, occurrence, and rights raised by the parties. The parties are not obliged to prove the law because it is lie on the responsibility, the task of judges. There is adagium called as ius curia novit, whereas judge considered to know the law. So judge is the one who got the authority to analyze, to examine the law. So we're going to talk about specifically on each of the evidences in civil procedure. But before that, we're going to overview the authority of judges, and it's very important because we're going to use that when we examine each type of evidences in civil procedure. The first one, judge determine the burden of proof, or in bahasa Indonesia, kekuatan pembuktian. So determine burden of proof, meaning whether the judges will give it evenly, for instance, whether it is strict liability. So you can search more on strict liability, specifically in a case of consumer protection, environmental protection, whereas the burden of proofs is higher to the accused one, the perpetrators, such as in environmental protection. For instance, a big company has more burden of proof compared to the citizen who submitted a case of environmental destruction, for instance. Next is judge got the obligation to determine the admissibility of evidence, or in bahasa we call as diterima atau tidaknya alat bukti. We're going to discuss further on each types of evidences, how could these types of evidences can be presented before a court and be accepted as an evidence. Finish with that if the burden of proof already set, and then the admissibility of the evidences are accepted, fulfilled by the evidences provided by the parties. Next thing, judge will determine the force of presumption, or in other terminology people use strength of evidence, or in bahasa kekuatan mengikat alat bukti. So how these evidences should bind judges. Okay? So accordingly to our civil procedure rule, as I mentioned, in civil procedure in Indonesia, there is no minimum number of evidences when judge want to render judgment. Why? Because accordingly to our civil procedural rule, there are three types of strength of evidence or force of presumption. That is why we don't have such a rule on minimum numbers of evidence. The first one is non-binding. Non-binding force of evidence, or kekuatan pembuktian bebas, or in other words is flexible. This is uh, this kind of force of evidence or force of presumption is for witnesses and judicial expert evidence, saksi and ahli in bahasa. So non-binding or flexible means that judges is free whether to use or not to use the evidence. If you look at, there's so many judgment, we could see that both parties or one parties uh, ask for expert testimony. However, in judge ruling, there is no whatsoever judges mention about the expert testimony. It is up to judge whether judge want to use it or not. Okay? Especially when it comes to uh, testimony that is not in same line with judges analysis. For instance, judges are not obliged to bind by it, and we're going to discuss further about witnesses and expert witness in another subject when we're going into details on each of the evidences. The second types of force of evidence or strength of evidence is complete binding force of evidence. So what do we mean by complete, or in bahasa sempurna? When we want to present such evidence, the evidence is sufficient to settle the case typically and don't need to be added or supported by the presence of other evidence, such as when we have this authentic deed, the authentic deed only is enough. Okay? However, it still open the possibility for challenge with other evidence, and the content is binding. Judge is bound by the content of evidence unless proven otherwise. That is what we call as complete binding force of evidence. Although it's still open the opportunity for other types of evidence from the other side. Okay? To that point of saying, then you can also, if you already got this complete binding force of evidence, you can also add other evidence, but the evidence itself can stand by its own. Next is complete strong binding and conclusive force of evidence, meaning that not only it can be submitted by its own, not only the content bind judge, it's also conclusive, meaning if there is the use of the evidence, the case is settled. There is no more obligation to do further examination or evidentiary, because it is what it is and it should be accepted. One of the example is decisive oath, or in bahasa sumpah desisoir, and pure confession, or what we call as pengakuan murni. That is why we don't have minimum numbers of evidence, because it lies on the types of evidence itself. Some of evidence are complete, some of evidence even conclusive. So those are brief explanation on Indonesia evidentiary as a foundation. And here in Indonesia, scholars believe that Indonesia has this classic or close evidentiary system. Why? Because our code, or our procedural code, HIR and RBG, already mentioned, namely types of evidence. It's different in many other countries, whereas in Netherlands, in France, for instance, they already amended their procedural code, whereas they're not right now specifically mention types of evidence, because due to the rapid development of technology, for instance, there are new kind of evidence brought out, and then that is why they avoid to mention by name, because in Indonesia we still got a problem with our new bill of procedural law, so we still use HIR and RBG, which is promulgated in 19th centuries. That is why many people believe that we are still in the stage of classic evidentiary system, although many other scholars disagree with that. By the establishment of Indonesia telecommunication law, Undang-Undang ITE, it is clear there's some types of new evidences accordingly by the development of technology of information. That is why many people believe Indonesia has been shifted from classic evidentiary system to open evidentiary system, although not yet as it is the same with the Netherlands and France. Next audio will explain in details each types of evidences. So thank you for listening.